The lone tough talker, Curtis Wright. There is no substitute.
First cup of coffee, and I've got Curtis Wright, so I'm pumped.
It's gonna be a good morning, a good morning meeting. We're gonna have a great time together.
I just want to thank you for getting it out there to the people.
This has always been about what's best for my community, my state, and my country.
Thank God for people like you.
We're back live here on The Beat. I'm Curtis Wright, WFNC 640 AM, WAAV 980 AM, covering more of North Carolina in the morning than any other morning talk show. On mic with us, we're honored to have as guest Gary Kreep. He's a well-known constitutional attorney, president and executive director of the United States Justice Foundation. And you'll be able to, again, listen to this interview after we're done. It will be posted on the website, and we're going to put a link up also to some information. Again, in the wake of the decision by the Supreme Court, long-anticipated decision by the Supreme Court on Obamacare, as it's called, lots of questions, actually, as well as a lot of emotion, anger, disappointment, and we could go on and on as we've been talking this morning. And hopefully here, and I know for sure for here, Gary Kreep will help us a little bit understand maybe the nuts and bolts and the implications of actually this decision that has come down. So welcome, Gary, and thanks for taking the time this morning.
Oh, thank you for having me on your show.
I really don't know where to start with a question, except I think it's most important to start just with this. Talk to me about your perspective and your reflecting on this decision that has been long anticipated.
Well, I think it's a terrible decision. I think that it flies in the face of Supreme Court precedent. I think it's a blow to the concept of our founding fathers and federalism, the relationship between the states and the federal government, or actually between the federal government and the states. I think that obviously we don't know why Chief Justice Roberts ruled as he did, going against his own stated beliefs in the Constitution, and ruled with the liberal wing of the Supreme Court. It seems like an agenda-driven decision, more along the lines of the ends justify the means, because Mr. Obama himself, in a nationally televised interview with George Stephanopoulos a couple of years ago, vehemently denied that this was a tax. Mm-hmm. His Department of Justice, his attorneys, argued in the trial court and in the appellate court and in the United States Supreme Court that it wasn't a tax. Congress, when they put this together, said it wasn't a tax, and the Supreme Court, according to their own precedent, is supposed to look to legislative intent, or in this case, congressional intent, in the drafting of legislation. And so we have basically, this isn't a tax, but Chief Justice Roberts, in an apparent attempt to maintain this legislation, come hell or high water, just made the unilateral decision that it was a tax, and as a result, we have a dramatic change in the relationship between the federal government and our states and our people, because now, under this precedent, they're literally, as Court Justice Kennedy commented, there's literally nothing the federal government cannot regulate in our daily lives.
You know, it's interesting, that one point, and I talked a little bit about it this morning. You articulated it better than I did, and that is, for a justice who has talked openly about how wrong it is for those to legislate from the bench, and, the guiding light should be the Constitution and on, he really went out of his way to shore up an argument that was really a deficient argument, an argument that couldn't be substantiated. He actually took the position of, okay, well, then I'll prop it up for you.
Well, there's been a lot of speculation that the Chief Justice Roberts was either personally hurt or considered the Supreme Court hurt by their ruling in the 2000 election, and that there's been a lot of speculation that he was concerned about what a ruling in this case, which some experts say is somewhat akin to that ruling, about what a decision in this case, overturning Obamacare, might do to the to how people view the United States Supreme Court.
And isn't that absolutely wrong, Gary? That politics should not be before the court. What should be before the court is the law and the Constitution.
I agree with you 100% on that. It's a completely wrong basis on which to make a decision. I mean, basically, we're looking back at things like the Everson decision, in which the Supreme Court drew the separation of church and state out of whole cloth, basing it on a letter from President Thomas Jefferson to the Danbury Baptist Association. I mean, had nothing to do with the law or anything else. It's just that was an agenda-driven decision by a Chief Justice who wanted to make his imprint on society and promote a social agenda. Same thing with Roe v. Wade. That was an agenda-driven decision made by a Chief Justice that wanted to put forth a social agenda. And that's what we have today. We have Chief Justice John Roberts, long viewed as a champion of the Constitution, throwing the Constitution overboard to promote a social agenda. Now,
this morning, David Bernstein in the Wall Street Journal is just putting forth. He didn't want to characterize it as a rumor, but things that are being heard. And in looking at the dissent that was written by Mr. Scalia, or the wording that was used by Mr. Scalia, there's a point where he actually says the dissent. So there's this. Well, wait a second. Was this actually this piece of writing actually the majority decision at one point, and then the Chief Justice stepped in and put that aside? And that's go ahead.
Obviously, that's somewhat speculation, and I'm not trying to be critical of either you or the author of that piece. We don't know. But what is clear is that there have been rumors circulating for months that the Obama administration was targeting Chief Justice Roberts with a political and public relations campaign, believing him to be swing vote in this and believing him to be vulnerable on this issue for whatever reason. There were also rumors that Justice Kagan, who, in my humble opinion, should never have been allowed to rule on this case, because she was part of the team that put together the legal defense strategy for defending Obamacare in court. She should never have been allowed to participate in this decision. Completely improper. But Chief Justice Roberts was doing about it. Maybe that's part of what's going on here. I don't know. But the point is that the Obama administration either knew something or figured out something that the rest of us didn't, and put a lot of pressure on Chief Justice Roberts. Now, there's a very famous story, behind-the-scenes story of the Supreme Court, that Justice Blackmun was originally going to vote to uphold abortion restrictions, and one of his clerks turned him completely around on the Roe v. Wade case and got him to go along with the idea that abortion is somehow a right, a constitutional right. So maybe something along those same lines happened here, but this appears to be very clearly an agenda-driven decision rather than a Constitution-driven decision.
And as you're saying, Gary, agenda-driven decisions, one, have only caused, and please correct me if I'm mischaracterizing, have only caused more controversy and disruption in America. And in some way, in these types of decisions have damaged both not only our country but the judicial system. Yes,
it doesn't really matter what you think about the issue of abortion. That decision was based on social science and claims of the abortion industry and medical abilities and things like that. It had nothing to do with the law, and that's what we're saying here. This decision has nothing to do with the Constitution on which it's supposed to be based. It's got to do with somebody deciding that, well, we need health care for everybody around the United States, and no matter what damage it does to our system, no matter what country it's going to raise. Because, apropos to your comments, this story. If the anger that I'm
Gary, you're breaking up on us, but I've got to go to a hard break. We'll be right back with Gary Kreep. Again, he's the president and executive director of the United States Justice Foundation. We'll work on that connection.
We'll be back in a minute with more of Curtis Wright on the Beat on 640 WFNC and 980 The Wave.
We're back live here on the Beat. I'm Curtis Wright. 8:49 in the morning. On the mic with us, of course, this morning is Gary Kreep, constitutional attorney, well-known constitutional attorney, president and executive director of the United States Justice Foundation. Gary, I think that this decision and some of the other decisions that you brought to our attention and reminded us of just, in your comments, just continues to me to raise this grave concern I have with America, this path that we're on. During the vetting process, if you will, for now Supreme Court Justice Sotomayor, she openly said, yes, I believe we should look to foreign law and we should consider foreign law and analyze foreign law when we make our decisions. And I'm sorry, maybe there's something wrong with me and maybe I don't have enough knowledge and background in the law, but if I were a United States Senator, I would have said, I'm done here. The reference point is the Constitution of the United States. And the other thing that concerns me is we've seen a president, this president in the last 3.5 years, openly say that I believe that, the Constitution is, it's a reference point, but, I disagree with this or I disagree with that, and I'm going to go in this direction. Even standing before a group of a special select committee put together saying, you know what, we're having too many problems with this doggone pain-in-the-neck thing called the Congress. Let's just go around them. This is of grave concern, and I believe that this decision reflects us going down further this path where the Constitution of the United States is not the reference point anymore. It's just sort of, we consider it, but, we've got, thanks for the input kind of idea. Do you understand what I'm saying?
Yes, and I share your concerns. I had held some hope out for Justice Sotomayor to even join in overturning Obamacare. Prior to the decision coming out, I believe that the ruling would be at least 5-4, possibly 6-3, and a remote possibility would be 7-2. I believe that the only firm supporters of Obamacare on the court, real hardcore ones, were Justice Kagan and Justice Ginsburg, and that Justice Sotomayor might be swayed. She had earlier this year joined in a couple of decisions that seemed to indicate that she had an understanding and a concern for protecting the original intent of the Founding Fathers, but obviously this decision blows that all out of.
And even wasn't it even her interaction during the presentation to the court? I thought she had some great questions that she asked and some great responses or interaction, if you will.
Yeah, it sounded like she was being critical of what was of the Obama administration's position on Obamacare, and I thought that again was the signal of positive things to come. I think the reality is that when Justice Roberts switched over, that may have caused other justices to rethink their position. I was just reading the article in Business Insider during the break about the way that Justice Scalia appeared to be writing his opinion as majority opinion, referring to the dissent, and also how Justice Thomas apparently failed to rename his dissent as part of the joint dissent and referenced it as part of the joint opinion because he ultimately wrote a brief, separate dissent, although he joined in the main minority opinion.
Well, that was what I brought up. I think Mr. Bernstein's bringing up. If you look at those two you just brought up again, that it looked like that, in fact, Mr. Scalia may have even been assigned to write the majority decision. And then at some point, because, right, the Chief Justice himself, once the majority is chosen, he makes the decision, right, on who's going to write the decision. Then it looks like he might have come in and said, okay, well, now I'm going with this is how I'm going with my decision. So thus we're now the majority. So thus I'll write it myself.
Well, what happens is that if the Chief Justice is in the majority in the decision, then he decides he assigns who's to write it. If
Yeah.
he's not in the majority, then the ranking, the senior Supreme Court justice decides who. The senior Supreme Court justice on the majority side decides who is to write the opinion. If it's not the Chief Justice.
And that wouldn't be far-fetched. That, in fact, that would be Scalia, wouldn't it?
Yes.
So, let's talk about going forward. I know there's of course, on the Republican side, everybody on the conservative my side is all, okay, well, no big, this is it. Okay, so the line's in the sand. We've got to change out the administration. We've got to get a majority in this, and we're going to repeal this. But I think it goes beyond that. Is there any other, in this decision that's come down in the way it's written, are there things, even if we legislatively go forward, that is still damaging, in your mind, to our principles here in the United States? Our constitutional principles.
Yes. This decision is a terrible decision when it comes down on the issue of federalism. It basically lays out a framework where any future Congress can decide, well, we're going to legislate on buying broccoli, or we're going to legislate on on divorces, and we're going to legislate on anything that the states had been relegated the power to decide. Remember, this is supposed to be a government of enumerated powers, and only enumerated powers. But now this decision basically says that if someone just uses the word tax or even implies that something is a tax, then that'll pass muster, and that gives the federal government broad powers. Now, one of the discussions that had gone on was whether there were in the opinions was, and I haven't read all of the opinions. It's 193 pages long.
Yeah.
I was busy yesterday trying to do some other things like making a living. But one of the interesting concepts that's come out has been the debate over whether there are criminal penalties for failure to comply with the Obamacare individual mandate. Mm-hmm. And it's pretty clear that there will be, just from a logical point of view, because, number one, the IRS had announced earlier this year that they're hiring, I think it was like 40,000 new agents to enforce the Obamacare mandate. Well, anybody who knows anything about tax law or anything about dealing with the IRS knows that if you don't pay a tax, then ultimately the IRS will criminally prosecute you for not paying your tax.
Oh, yeah, and they can seize property, they can confiscate, they can garnish, they can do all kinds of things.
Right, so the situation is such that the whole idea, we're not going to have a criminal prosecution, that's gone out the door because now we've declared it a tax, and the IRS is going to, apparently, since it's a federal tax, the IRS is going to be enforcing it. They will criminally prosecute people who don't pay it. Some months back, I was contacted by, a dozen or 24 people from around the country who said that they're not going to pay this, and they'll risk criminal prosecution over it. My foundation has already agreed to represent them in those cases, should they be brought. So, we could be quite busy starting very soon.
Playing with the judicial system, like I said, there's far too much politics in all of this, sadly, and you call it agenda-driven decisions and, and messing around with our judicial system. It's supposed to be about the law, about the law, about the law, and about our Constitution, I should say, to be more clearly. This is almost becoming, and this whole thing you're talking about with the IRS, it's a bit of anarchy in the sense of, think about it, how crazy in America that you could be criminally prosecuted because you don't have insurance, but you can be in this country illegally, working illegally, doing all kinds of things illegally, and nobody's going to prosecute you at all.
That's right, because the Obama administration has shown that it's willing to basically ignore the law, ignore the Constitution, time and time again. We could spend a couple hours on here going over with you a variety of very well-known court cases that I've been involved with personally as an attorney.
But it's almost judicial anarchy in a sense. This whole thing has gone so far, and especially with this administration, it's like judicial anarchy.
Yes. Well, it's actually the Constitution. It is anarchy. Not necessarily judicial anarchy, but governmental anarchy. Because Mr. Obama, to him, the Constitution be damned. He's going to do what he damn well pleases, and he doesn't care what the cost is.
Well, Gary, thanks for being with us, and we appreciate your taking the time. Gary Kreep is a well-known constitutional attorney, president and executive director of the United States Justice Foundation. Check out their website. The link's on our page. I'm Curtis Wright. Stay with us when we get back. It's the Morning Wrap till 10 o'clock. There's lots more to talk about.